Today on Off the Clock, we are going to talk about the do's and don'ts when employees publicly badmouth the organization. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. Last time we talked about terminating employees' employment with the organization, and today we're going to talk about the natural next step, which is bad-mouthing the organization. What to do about that.
We are so uplifting.
Yes, we are.
If you're feeling down already, you should probably not be listening to us for the next few episodes. But so this is, in my experience, the call where my secretary pulls me out of another meeting.
Yes, right. Like there's
is
an
that your
emergency.
Too?
Yes.
Yeah.
Somebody is on Facebook saying disparaging
or
things.
I'm out of town and my assistant reaches out to me and says, I know you're out of town, but so-and-so says they need to talk to you.
Right now.
Right now, it's urgent, et cetera, et cetera. And I think, my God, right? There's a workplace violence situation, et cetera. And when we get on the phone, it is this, right? There's a critical... what lawyers would call disparaging, but has been pointed out that's a very legalistic term. But they're saying something bad about you.
Right.
And it's not just to their buddy at the bar, right? It's gotten back to you because it's on social media, it's on one of the hiring platforms, it's on one of the rating sites, right? It's on someone's own Facebook page, right? And then other employees have chimed in and someone has printed it out and brought it to you. And
that's
now...
right.
People are upset.
That's right.
Right? The supervisor, whomever's getting badmouthed, is
that's right.
Angry.
Yeah. And I mean, not to state the obvious, but it used to be that our days were consumed with employees who make internal grievance complaints or file administrative charges, or even if things really escalate, file a lawsuit.
Right.
And for each of those things, there's a set process and a fairly clear path for how to respond and how to tell our side of the story.
Or, to be honest, a lot of times it was, again, talking to your friend behind a closed door or at a bar or complaining to your spouse when you got, let's be honest, right? These same things were said, but now those types of conversations people used to have are now just were culturally acclimated, right, to putting those out there, right?
So now when some employees are upset and reactive, right, instead of writing a nasty email to their supervisor, et cetera, they will go on social media and rant.
Yes.
Maybe that's the right word for what we're talking about. Rant, complain, say very negative things about the organization on a social platform that the whole world has access to.
Some sort of public way. And that feels like an emergency.
It does,
right?
Because we can't control it.
Yes.
That's why it feels like such an emergency.
It's so something urgent.
Yes, it's something bad. It's something that is negative to the organization, and there's a lack of control on our part about what to do about it.
And there's anger, right?
Yes.
There's just anger, because usually, oftentimes, there's been a little history with that point. Let's just be honest. Yes. There's been a little bit of history. So someone's already angry at that employer, irritated by them, and then that just is the straw, right? The final straw.
Yeah.
So my first response is to take a deep breath. Now, we are not psychologists or therapists. We are going to get to some legal solutions too. But the reality is probably not that many people will see this thing that's out there. Few of these types of things go viral. Okay? They do happen, and that's what's in our minds, and that's what we're scared about. But the reality is, think about the sets of eyes that will actually see that, and it's probably not going to do your business in.
Yeah.
Okay, so deep breath.
And that piece, and we'll talk about this a little bit more, but that piece also depends on whether it's on this individual's own social media platforms, in which case it's largely their own friends and family.
Right.
Or it's on the organization's social media platforms, in which case it might be seen by people we care more about,
Right.
like our customers, our vendors, our other employees, etc. Right?
Yep.
And potentials of those. So I agree with you, though. Just take a deep breath, step back, think about who is going to see it, and why we care about those potential readers. Does that make sense?
It absolutely does.
So the first question I usually get is, from a legal standpoint, can we make them stop?
Yeah.
Right?
Yep.
That's the $1 million question. And the circumstances in which, from a legal standpoint, we're going to be able to demand they stop or get a judge to make them stop are pretty narrow, right? Do you agree with that?
I do agree with that. Yes. First of all, let's just make sure everyone understands what we're talking about. We're talking about private organizations and not public bodies, because it did occur to me that, right, people with public bodies, there's First Amendment rights, et cetera. So we do want to make sure we're just talking about private employers and private bodies. And I do think it matters somewhat whether someone is a current employee or a former employee.
Oh, we'll get into that.
Because, but in either case, you're gonna probably have to make a claim that this person has engaged in defamation
or slander.
Okay, and the definition of that, which you know, is it has to actually be provable to be false.
Yeah.
And someone's opinion, almost as a matter of just black letter law, someone's opinion cannot be defamation because it is their own opinion.
Right.
Right? So let that sink in for a moment.
Right.
So if someone is expressing their negative opinion of your business, of their supervisor, of your product, that really gets under people's skin.
Yes.
If it's an opinion, it's not going to be defamation.
That's right.
Yeah.
Right. If they're stating it as if it's a fact and it's patently untrue,
Yes.
then there could be legal action you could take.
Right.
We often start with a cease and desist communication, right? The scary, you better stop what you're doing because it violates the law, and if you don't stop or take it down by a certain date and time, we are going to file legal action, et cetera, and then follow up and do that. But that is the more unusual circumstance that we have the ability to do that, quite frankly.
So let's talk about first current employees.
Okay.
Right? Because that's a little more challenging,
Right.
I think. When they are bashing, is that a non-legal term?
Yeah.
When they're bashing you?
I like that.
Okay.
Bad-mouthing, bashing, et cetera.
Yes,
Yeah.
when they are bashing you on some sort of social media or hiring platform, whatever it is. What can you do?
Right. If
Or
it's a
actually,
current-
we just said what can you not
Right.
do
Right.
employment-wise?
Yeah. So the first thing that I hope would jump to our listeners' brains is protect and concerted activity
Okay.
under the National Labor Relations Act. And this is just a reminder, right, for our listeners, we cannot take employment action against any employee for engaging in what's called protected and concerted activity under Section 7 of the NLRA. Protect and concerted has two parts.
Okay.
The protected part means it's about the terms or conditions of their job or their employment.
Okay.
Okay. And concerted means that it's with or on approval by their coworkers.
Okay.
Now, I want to make an important point, and hopefully we'll bring this up a few more times because I don't want this to get lost. Only non-supervisory employees have Section 7 rights.
Okay. So
Okay,
that's
so we're talking
important.
about non-supervisors, right?
Yes.
They've got a right to engage in protected and concerted activity. So you're wondering, I'm sure, how is a non-supervisory employee posting negative things on, let's just take the stereotypical, their Facebook page, or maybe our Facebook page. How is that protected and concerted?
How
Right?
did you know?
Aren't they
That was
just
my
complaining?
question.
Aren't they just complaining?
And what if they actually name their supervisor?
Right?
And what if they just are complaining about their supervisor? Is that a term and condition of employment? Yes, if they say their supervisor is unfair or is a jerk or should have given them a promotion or just sent them home unfairly, et cetera, those would all easily fall under terms of conditions of employment.
That's right. And that gets to the protected part.
Yes, I'm so curious
about the concerted part, right? So remember what I said. The concerted part is with or on the authority of their employees. It's that with part, right, that can elevate Facebook rants to concerted activity under the NLRA. Here's because many individuals are friends, quote unquote friends, Facebook friends, with who? Their coworkers.
Don't recommend.
I don't recommend. But if you want to engage in protected and concerted activity,
total
I
side
do
note,
recommend.
personal advice, right?
So let's take an example.
Okay.
So there's one case where the NLRB took the position that it violated Section 7 to fire an employee for doing this. The employee went on her Facebook page and called her supervisor a scumbag. And I don't think I can say this word, but so
Why?
I'll save Jeff from.
Are we regulated?
Yeah, by Miller Johnson we are. From calling her supervisor a D word that refers to the male anatomy.
I still don't understand.
Yeah, right. On Facebook page, and then the employee's coworkers posted supportive comments on Facebook, which will happen. That will occur. Somebody goes on a rant on Facebook, has a strong opinion. There is going to be somebody out there who says, I'm so sorry you're having to deal with this, right? Blah, blah, blah. That department sucks, etc. NLRB said that's protecting concerted activity and it violated the law to fire the employee for doing that.
Wow.
Okay.
The employee that originally posted.
Yes.
Who had no idea if anyone would actually comment when they posted.
Correct.
It still is protected and concerted.
According to the NLRB.
And just to play that out, that means they can't be fired or disciplined for it.
Correct.
Because that's the question we get.
Correct.
Can I fire them?
Correct.
For doing such and such. So the answer is no. If it's protected and concerted, the answer will be no.
The answer is no. That's exactly right. Now, not all behavior is protected under Section 7. Notwithstanding that example, there are things that are so extreme that are not protected.
Like what?
Given the current board's view of protecting concerted activity, it's a sliver about that big, okay? So here's the takeaway for our listeners, right?
Yeah.
If they are considering disciplining or firing a current non-supervisory employee for bad-mouthing us on social media, please contact your favorite employment attorney and talk about it first, both about the legal risk, but also there's some strategy to how you communicate that decision if you're going to move forward and which maybe posts you rely on. Yeah. Maybe there are posts that didn't have comments by coworkers, for example. Okay.
Smart.
There's strategy. It's important to sort of put a flag in that and be aware of that as a significant issue.
So let's talk now about supervisory employees, because some of them get angry too. Yeah. Right? Hopefully less often. But it certainly happened. Absolutely. And let's face it, sometimes after people have been drinking, maybe, right? It's the 2 a.m. post. Then they wake up and delete it, but someone else has already screenshotted it, printed it, put it on HR's desk, and now it's something you have to deal with. So if it's a supervisory employee that has bashed the company on social media overnight or whenever, we don't have to worry about the NLRA, right?
Correct.
We don't have to worry about protecting
Section 7
activity.
under the NLRA, yes, assuming they're a true supervisor as defined by the NLRA. Right. That's correct.
So can we fire them for doing that, Sarah?
I think potentially you can. There's still a few more things that I like to think about before moving forward with a decision like that. Number one is potential discrimination concerns, right? Generally speaking, employers don't go out of their way to fire employees for what they do or say outside of work.
Right. No one has the time. Let's just be honest.
No one has the time.
No one has the time to be following employees around and paying attention.
So let's just make sure that this decision, right, we're confident that this decision is based on objective information that we can support, and we can distinguish why this is elevated to the degree that it has to result in that discipline versus maybe other information we've had from other employees that did not. Boy, this kind of really circles back to our last two-part series on terminations. But, and the second caveat, I would say, the second additional legal consideration is just a reminder there is a federal law now, and several states have passed laws that protect employees for talking about sexual assault and harassment in the workplace. Okay, so if the post had to do with sexual harassment or assault, we would want to make sure that we are not sideways with any of those laws before taking action as well.
That is a good point.
Other thoughts from you on supervisors?
I am pro considering termination in those circumstances.
Yeah.
I think it's case by case. I think it's very helpful to engage in, not a full-on investigation necessarily, but before making a decision, I find employers want to go straight there because they're like, well, look, I have the thing right here. I find it's very helpful to talk to the person. And then if the termination is their decision, yes, you still, even though you have a printout or what have you, you're still going to want to know what happened, what led up to it, etc. You want to, even though that's obviously inappropriate to embarrass the company like that publicly as a leader of the organization, you probably want to know what led up to that moment, right? Maybe there's things that happened on their team, et cetera, that pushed them over there. It's still not an excuse, but things as HR you're going to want to follow up on.
Could be mitigating factors that or you would want to know about.
Maybe someone mocked it up, or they're going to say they're going through a divorce, for instance. This is what I've heard. They're going through a divorce and their spouse, got access and is trying to get them fired.
We've heard it all, haven't we?
We have heard it all. Yes, I've heard all of those things. Yes. So you don't want to miss that step before you get to termination to hear that person's side of it. And if they admit it, then it's
great advice.
Most people will assume they're getting fired in that moment. So.
What do you think? So we are seeing more and more social media policies from employers having a policy in place that when it happens, they can point to the policy and say, you have violated our social media policy. What do you think about having a social media policy in place?
I think social media policies, like all policies, are a good idea. I think in the current labor environment, I'm just being very straight with you right now. I don't know how you write one that would accomplish your goal here and pass an LRB.
For non-supervisory employees.
Right, yes. And I don't think you're going to have a policy or a handbook that says non-supervisory employees may disparage, may badmouth that, but supervisory employees, this is strictly... that's not how policies are written, obviously. So the policy is going to purport to apply to everyone. And with the current board, even if you don't actually take employment action against non-supervisory employees under the policy itself can cause a world of hurt.
Yeah.
And I just don't know the practical answer to that, because it would be so watered down. I don't know if it would actually help you rely on it. Yeah. If you could rely on it in a termination.
Based on the current board.
That's the quandary I'm in. What about
you? The current board has been very clear about their view of social media policies, non-disparagement policies, et cetera. They view even the concept itself, the idea that we would limit employee speech to likely violate Section 7. Now, that doesn't mean we can't have one and do our best to have a disclaimer, right? You can put a disclaimer in those policies that say, don't read anything in this to limit your right to engage in protecting assertive activity. I laugh because you can't also have language that does violate their right and then tell them not to read it that way, right?
Right.
Can you have one right now that gives you an argument that it passes muster? Maybe, but you would not want to. That is something that, again, you would want to use legal counsel. To find that balance for sure.
And for organizations that currently have social media policies, which is frankly, just about all of them now
Yeah.
have that in their handbook because of the latest NLRB activity. And that is not the purpose of this podcast, but also there's some difference in how it's just much easier for unions to organize, especially if you have any sort of unfair labor practice, which, a too broad social media policy in a handbook could count as. This is a good time. Right, to consult with legal counsel about your whole handbook, frankly. But we're here to talk about social media. So the social media policy, you're going to want to take a careful look at that.
Yeah.
Right. In this
the one thing I would add, though, too, is you could have an agreement with a separate agreement with non-supervisory employees that covers social media and non-disparagement. If an organization wanted to use that approach, to have something that they can really point to for non-supervisory employees.
But I completely agree with you. Maybe include it in some agreements that you're already having supervisor, executive level sign, non-competes, confidentiality, other things. But I'm just going to take us on a little side trip just for a second, I promise. But this is where a lot of HR folks I find sometimes get hung up, particularly earlier in their career. You don't have to have a policy directly on point to take an adverse employment action against someone. You will never be able to predict all the crazy, terrible things humans can come up with in the workplace to do.
Yeah.
Right? I mean, we've both seen just
I think that's
outrageous things. So even if your social media policy is bland enough that the NLRB is going to say it's fine, that is a consideration when making an employment termination decision. But it is not necessarily the determining factor.
I think that's right. I would just add this. For non-supervisory employees, if you actually had not a policy but an agreement, then you could get a court to make them stop doing it if they don't, or make them take it down.
It's easier.
It's easier because then you have a breach of contract.
Yeah, you don't have to prove defamation. It can be absolutely true. But
That's
still
exactly
paint you in a poor light. Yeah. And if painting you in a poor light publicly on social media is a violation of their contract, then you've got a claim.
Exactly.
Yeah.
And you might be able to get a judge. And that's also ammunition to put in a cease and desist letter, right? Yeah. You are not just you're insulting us and you're impacting our business, but instead you are in violation of this agreement that you signed, and if you don't stop, we're going to file an action in court and make a judge issue an order to force you to stop or take down what you've posted. So setting aside the legalities of it all, then, right, what do we do when we have, for example, a non-supervisory employee that posted mean things about the organization or their supervisor? What do we do? Do we meet with them? Do we order them to take it down? What's your view on that? How do you navigate that when clients contact you with those questions?
Yeah, well, I think it's, again, aside from the legal factors and whether that's protected activity or not, I think this is where culture really comes into play, right? Because this person will tell other employees what you did in response. And I think when we express that we are outraged, right, and frustrated and insist on it being taken down immediately, and we acknowledge through those actions that we don't have control and we're trying to get it back, we have acknowledged that we don't have control. And it's not a good look, frankly, right? It's not a good look. I again, encourage us to take a deep breath. We are in control of how we respond, right? And I think we come across as more confident in our culture, in our workplace, in our supervisors, and everything if we don't allow dissension, either in the workplace or on social media. I do think, again, depending on the specific circumstances, I do think you should seriously consider bringing that employee in and talking to them about, I don't think if it's protected activity, you can require them to take it down, because then the employees will say, or what? Well, then you'll be fired. Well, that is right. You can't do that. But I do think it's helpful to bring the person in and say, you're obviously very angry. What's going on?
Right. Well, that's what I was going to say. If you're going to have the conversation with them, if you decide to follow up with the employee and maybe ask them to take it down or stop, I don't think you can have that conversation without addressing their underlying concern.
Right. Well, yes, let's not forget about that. And this is very, very hard for the HR people in the middle of this, because the business leaders will just be furious. right? But this is where HR can add value
Right.
to the process by being, right, the level head in the room and saying, we have a problem, right? And maybe you're going to find out you have a supervisor really is, maybe not the D word, but maybe there's room for improvement, right? Maybe you do have a bad supervisor. Maybe you do have a bad decision, or maybe the person has other reasons to be frustrated, but just giving them the outlet to talk to someone who matters in person and vent that way. Think about the story then that will get told on the shop floor, right? Instead of so-and-so said, if I don't get, versus, you know what? They weren't happy that it was, and you can be honest about that. I mean, well, that was, an unpleasant discovery this morning when we learned that you posted that, but what's going on? Right. I mean, think about what they tell their colleagues on the shop floor about how you actually wanted to know what was going on. That's a completely, that's just a different culture, right? And probably a better culture that you want to foster.
Right. Yeah. I mean, my view is it's just so case dependent. It depends on the employee. It depends on the concern. Sometimes it's a concern that we've known about and we've been up and down and around with that person on it. And there is no resolution to be had. We simply disagree, right? Employee believes X. We've looked into it. It's just not true. And so I think more often than not, though, the more reactive we are, the more likely the employee is going to escalate rather than de-escalate. From time to time, there's an exception to that, right? From time that I've seen organizations successfully have conversations with employees to help them understand how what they've said reflects negatively on the organization and what that means, and that individual has apologized and said, I acted in the heat of the moment. I'm sorry. I understand what you're saying. And everybody holds hands and sings Kumbaya. That is not usually what happens, though.
No.
Right? That is not. And so going back to your original comment, I think that you made, which is think carefully about what the concern really is here. Is this an emotional concern because we have individuals that are mad or even embarrassed that things were said about them on social media? Or is there a real business concern? Are we worried about customers pulling their business from us?
Right. And usually that won't be the case.
And if it's the former, then we might just need to take a deep breath and let this be the flash in the pan of the day, because something else is coming tomorrow and everybody will have forgotten about it. The more we try to talk about it, it just keeps
very
to the top of the page, right? It just keeps
self-defeating.
It's very self-defeating.
Yeah, I completely agree.
So the only reminder I would have, just one last thought, is don't forget we control our own social media platforms.
Oh, yeah. That's the easiest one
That's
to
the
handle.
easiest one. Okay.
Delete their comments.
Delete their comments.
Yes, you can do that.
I've had many conversations with employers who are exiting individuals from the organization and are very concerned about how they're going to react. On your checklist should be either shutting off, temporarily suspending the public's ability to comment on any of our platforms, and or making sure somebody in your organization is carefully watching those so that we can immediately take down any negative comments on our own pages.
Yep, agree. Okay, well, this was super helpful, Sarah.
Yes,
thank you so much.
Rebecca.
Bye-bye.
Bye-bye.